You the legal edge, and this evening local attorney Bryan Waldman and I tackle a common misunderstanding that people have about their rights in the workplace, specifically if they can bring a case against their employer when they're injured or sick on the job.
This is one of the most common calls we get at our law firm, and people are frequently surprised at the answer to this question. Someone will call and say, hey, my employer put me on a machine where they had removed the guard and I was injured, or they put me in a position where I wasn't trained to work with certain chemicals and I was injured. What claim can I bring against my employer? And the answer to that question is the only claim you can bring with regard to something that your employer does that's negligent or at fault or even a coworker is for workers' compensation benefits. That's called the Workers' Compensation Exclusivity Rule, which bars what's known as a liability or negligence claim against an employer or a coworker.
And that's it, huh? Is there reasoning behind this or logic behind this rule?
The logic behind this rule when it was passed is we want employees or workers to be able to get certain things, even if they're at fault, and we want them to be able to get those things quickly without long drawn out litigation. And so we're going to create this workers' compensation system, which by theory is supposed to be a quick remedy for the employee. They're supposed to be able to get their wage loss and their medical paid quickly. And in return, what they give up is that liability claim against their employer or coworker. In Michigan, the two biggest exceptions, and really the only two exceptions, are if the employer is required to purchase workers' compensation insurance and doesn't, they then open themselves up to liability claims, or if the employer does something to intentionally harm an employee.
How does this translate into what's happening today, where we've got COVID-19, what we call essential workers and frontline workers?
If someone is injured on the job, they get sick from COVID, they'd be entitled to bring a claim for workers' compensation benefits, but they would have to prove that they contracted the COVID on the job. And that's why certain states, when they passed their COVID legislation, have said that if they test positive and they were exposed, there's going to be a presumption that they got the COVID at work for purposes of making a workers' compensation claim. To my knowledge, Michigan hasn't done that and hasn't even talked about doing that. And then for there to be a direct cause of action for negligence against the employer, you'd have to show that either the employer didn't buy workers' compensation insurance when they were required to, or that they somehow intentionally exposed someone to COVID to try and cause them to be injured.